What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Wednesday, February 5th. Hope you guys have been doing well. Your girl got hit with flu A last week. I have to say, it's the sickest I've ever been in my life. 2 ER visits later, and the hallucinations that I had with these fevers rivaled that rave I went to in the 90s, and that is saying a lot. Still not 100%, but the fever's gone. So I wanted to catch up on some things that's happened in the last week. One reminder, starting Monday, February 10th, I'll be covering the Rose Petal murder trial here in Greenville. You guys remember last month that was delayed due to the fact that most of the jurors that were sent summons didn't show up. So we are restarting, and I will be in the courtroom every day. I'll be live streaming the trial, and as usual, I'll be recapping each day's testimony in an hour or less every night. So keep your eye out for that. Also, I will finish the last witness in that Kouri Richins 2-day hearing that we were going over before I got sick. I have not finished watching that testimony yet, but she was back in court this week to hammer out how jury questionnaires might work given the high profile nature of this case. The judge said that being 2.5 months away from jury selection, he does feel some compulsion to get this process moving. The plan is to send out 1,500 questionnaires and then narrow that down to 200 by the time jury selection starts on April 21st. They also decided both sides and the court will change the question format so that the jury pool will answer on a scale of 1 to 5 as opposed to yes or no. They will address this issue again at the next hearing on February 21st. The best news I've heard all week since I've been sick is in the Ellen Greenberg case. I did a backstory on this if you're not familiar with it or you need a refresher. I'm going to link that. Just a quick recap. Her death was ruled self-harm in spite of the fact that she had 20 stab wounds and in several places where it would have been impossible to do that to herself. And not to mention, more than one of those wounds could have been fatal, rendering her unable to hurt herself. To say this case has always stunk to high heaven is putting it mildly. On February 3rd, there was a settlement between Ellen's family and the city of Philadelphia before their civil case was set to begin. Her parents were suing the city of Philadelphia for emotional distress for the mishandling of Ellen's death investigation. Now, 2 days before the civil trial was set to begin on January 31st, and the same day a judge ruled he would have to testify, medical examiner Marlon Osborne, who performed Ellen's autopsy and ruled her death self-harm, has now changed his opinion and said now his professional opinion is Ellen's manner of death should be designated as something other than self-harm. He said, I've become aware of additional information I did not have at the time of issuing the amended death certificate, which may have impacted my opinion. I'm now aware that information exists which draws into question, for example, whether Ellen's fiancé was witnessed entering the apartment before placing the 911 call, whether the door was forced open as reported, whether Ellen's body was moved by someone else inside the apartment with her at or near the time of her death, and the findings of Dr. Lindsay Emery from her neuropathological evaluation of Ellen's cervical segment sample. Initially, Dr. Osborne ruled her death was a homicide, but police publicly challenged the findings, and then he reclassified her death as self-harm. Dr. Osborne's reasoning were no footsteps were found in the snow outside of her apartment, indicating that either her killer left through the front door and locked it again, or Ellen took her own life. Now, more recently, just last year in November of 2024, the Chester County District Attorney's Office said they could not prove beyond a reasonable doubt that a crime was committed, and the investigation was put in an inactive status. The Philadelphia Police and the Philadelphia District Attorney's Office both investigated Ellen's death. There is no statute of limitations for criminal homicide in Pennsylvania, so tick-tock. Ellen's parents are also asking the Pennsylvania Supreme Court to have their daughter's death certificate amended from self-harm to undetermined. That has not been heard yet. A part of the settlement is that the medical examiner will reopen the investigation. And I think it's safe to say right now, the world is watching closer than ever. Let's hope finally justice for Ellen and her parents, but this is a great step in the right direction. Moving on to Lori Vallow. Her motion to dismiss the conspiracy to commit murder charges in the Brandon Boudreaux case was denied. She argued the delays went beyond her right to a speedy trial, but the judge ruled the delays were permissible and appropriate based on the circumstances of the case. He ends the ruling by saying that the trial for the attempted murder of Brandon will begin soon after the trial for Charles Vallow concludes, assuming Lori is ready for back-to-back trials. The last day in the Boudreaux case remains May 11th of 2025. On January 28th, the state filed a motion wanting limitations on the media coverage for this upcoming trial set to begin March 31st. They do not object to cameras in the courtroom during the trial, but they are requesting that the court preclude any media filming, photographing, or recording during jury selection. They say the presence of media filming, photographing, or recording during jury selection may inhibit potential jurors from expressing their honest opinions and could result in a jury that's not impartial. They're also asking the court not allow live streaming, saying that if the media accidentally films a juror or any conversation at the bench while live streaming, Court TV, who is the pool camera, would not be able to stop the public from seeing the juror or hearing these conversations. They end the filing by saying that not live streaming would allow Court TV the time to redact anything that was inappropriately recorded before airing it for the public to view. Lori filed her own objection to Court TV's request to stream the upcoming trial. She's asking they be denied. In a filing from January 31st, Lori says they object to Court TV's request in its entirety because of the bias they have already created in the community. Namely, Lori Daybell and her husband Chad Daybell are the commercial for Court TV. That commercial runs constantly throughout the day and has falsely characterized and slandered the defendants. Court TV should be ashamed of its very nature and its request, since its sole objective is not to bring people real news or facts, but instead its objective is to entertain the public with the very true life tragedies that happen in real people's lives. The defense objects to Court TV being allowed by this court to participate in this judicial process, including their specific request to appear at trial, live stream the proceedings on the web, and distribute the live feed. So we will see what happens there. Just a very quick update about Luigi Mangione. Yesterday, a federal judge appointed a death penalty expert to Luigi's defense team. The charge of murder through use of a firearm is a death-eligible charge. Other than that, not much going on there. Moving on to Donna Adelson. She gave surprise testimony last week at a hearing. She says there are 2 inmates at the Leon County Jail she wants to have testify at her trial, one of which she met at the jail art class. Donna told the court the inmate heard Katie McBanawa admitting to setting the Adelson family up, saying, quote, "She said, wait till I come back. I'm going to take care of that family. Wait till they see what they're going to get, and I'm going to get a reduced sentence," end quote. Donna also testified that one of the inmates told her that Katie said if her plan worked, she would be in Hawaii drinking a fancy drink. Donna also said one of the inmates told her about a tattoo that Sigfredo Garcia apparently had of Katie with a machine gun. Donna's attorneys want the 2 inmates to sit for depositions now, since they're going to be released soon and also have prior drug problems, which could potentially make them unable to testify at Donna's trial and also hard to locate once they're released. Judge Everett denied that motion, saying he didn't see prior drug use as a guarantee the potential witness wouldn't show up. His suggestion is the defense subpoena the inmates if they want them to testify. So that's it for Donna as of now. And just a quick little update about Charlie Adelson. You guys know we did an episode on him wanting to be resentenced. That was denied. So we will see what else comes up in their cases. And that's going to be it for today. I just wanted to update on these cases before this news got even older. Life happens sometimes, I guess, and we just have to pivot, right? Hope you guys have a good rest of your afternoon, and we will see you soon.